Welcome back, everybody. I'd like to introduce our next speaker for our breakout session, which is going to be an overview of expungements. So I'd like to introduce Arianna Eddy. She is the Senior Staff Attorney at Iowa Legal Aid. So she's going to, again, educate us on what expungement looks like and the benefits it has reducing barriers, legal barriers for those that are justice involved. Just a reminder, if you could please stay on mute and use the chat if you have questions for us, and I will try to keep an eye on the chat as well to make sure we get your questions answered. Go ahead, Arianna.
Hi, everyone. Do you want me to share my screen?
You should have the ability to do so.
Okay, awesome. Let me go ahead and get that going. Okay. Hi, everyone. I am Ari with Iowa Legal Aid. Here we go. So I am a senior staff attorney with Iowa Legal Aid. I've been working with Iowa Legal Aid since 2019, I believe. However, we have been doing expungement work since 2017. We started doing it after the events in Ferguson, Missouri. In 2014, that Ferguson report revealed that there was a role in court debt revenue generation policies as a major driver for abusive policing practices. And so we formed a committee to see if these things were happening in Iowa, and we found, unfortunately, that they were. And so we created the committee and this project to help combat that. And we had a first clinic that began on June 10th, 2017. And so we do this really to reduce barriers to self-sufficiency and to combat racial injustice caused by criminal legal involvement. So those who do have criminal legal involvement have barriers to employment, housing, education, transportation, and even the ability to volunteer. And then we also host in communities with statistically significant disparities in poverty, unemployment, and incarceration rates for African Americans. You'll see these stats here. These are from, I believe, 2021. Iowa ranks 7th worst in the nation for the percentage of our prison population that is African American, 25%, while African Americans represent just 4% of the state's population. In addition, African Americans, Iowans are 9.1 times more likely to be arrested than white Iowans, and Iowa ranks among one of the worst in the nation for Black individuals arrested for marijuana possession, while with a Black person being 7.3 times more likely to be arrested than a white person, even though studies show that both groups use at nearly the same rate. Let's see. Here are some graphics that also show some disparities in Iowa. You'll see on the right side, this is just a comparison from Iowa to other countries in the world. You'll see that the United States has a rate of 664 incarceration rate, and Iowa is right up there, 582. But you'll see, United Kingdom 129, Iceland being 33, Italy 89, France 93. You can just show that our rates are very high. And then in comparison to Iowa prison rates and Iowa jail rates, you can see the disparities when it comes to race. And this graph as well shows that as well, comparing Iowa's residents and incarcerated populations. The data states that Black and Hispanic Iowans are overrepresented, while white Iowans are underrepresented behind bars. So we do this, we address barriers and injustice through criminal record expungement and juvenile record sealing, and also through court debt management and reduction, we help with driver's license reinstatements, car registration issues, and then also dealing with private entities as well. So like those private debt collectors, private background check companies, mugshot websites, things like that. So to date, actually next week will be our 65th clinic since 2017, and it'll be in Cedar Rapids on April 25th. We've hosted in all of these different cities: Des Moines, Dubuque, Davenport, Mason City, Cedar Rapids, Waterloo, Muscatine, Ottumwa, Marshalltown, Oskaloosa. And then during COVID, we during 2020 and 2021, we did virtual clinics over Zoom. And we can't do these clinics without our community partners. We have about 50 right now, and volunteer attorneys. We're almost to 200 volunteer attorneys so far. Our biggest clinic was in Cedar Rapids, and we served 148 clients in one day. We'll never do that again. It was a lot. We typically get about 20 to 40 clients per clinic now, just to keep it more manageable. But that was a fun day. So to date, we've almost served 3,000 Iowans. 55% are women, 43% are Black, Indigenous, or people of color. 25% of our clients live with a disability. The most expungements we've done for one client has been 27 expungements. And the most debt that we've been able to discharge is for one client is almost 40 grand. And we help people from 17 all the way to almost their 80s. Yes, records can still affect someone in their 80s. Here's kind of a snapshot of what the clinics that we have done this year and where we're planning to have them. Like I said, April 25th is our Cedar Rapids clinic. June, we are having a clinic in Fort Dodge. July, Waterloo, and then you'll see that we are looking to schedule clinics later this year in Storm Lake, Davenport, Sioux City, and Dubuque. So now I'm going to go over just in general record clearance law. I promise it won't be super boring and I won't use a lot of legalese, but just to give you an idea of what Iowa has, I will go over that. So we got our first record clearance law in 2015. It was our juvenile sealing statute. So I'm going to talk briefly about that. Our misdemeanor conviction expungement statute, dismissal expungement, deferred judgment expungement. And then the last three work the same way. So public intox, possession of alcohol under legal age, and juvenile prostitution expungement. I will wrap those together for you. And I see there's a chat. Will these PowerPoints be sent out to all the attendees? I think I can at least, if not, I can at least make sure that I can send my PowerPoint to whoever needs it for people to have it. So juvenile sealing of adjudications. Adjudication is really a fancy word for a conviction. And then dismissals are cases where the person isn't found guilty and the judge basically dismisses the case. So for juvenile cases before 2015, a person needs to apply to have their juvenile record sealed. But for cases after 2015, there's usually an automatic hearing that's set 2 years after the date of the juvenile case closing and when the youth has turned 18. So the way how this works is if the youth is 16 when their juvenile case closes, that automatic hearing will be set when they're 18. But if they're 17 when their case closes, then they have to wait until they're 19 to get that hearing set. There are some limitations to this. A youth can't be on youthful offender status, which essentially means that if they're nearing 18 and they haven't done everything that they needed to do, that they are court ordered to do, that judge might decide to transfer it to adult court. If that's the case, then that juvenile case will remain open to the public. And if a youth has a newer conviction, that's at least a serious misdemeanor, aggravated misdemeanor, or pending felony, then they're not eligible to get their juvenile record sealed at all. So the way how that works is usually what we see is if during that 2-year time period that a person has to wait to have that automatic hearing, if they're subsequently convicted of a serious misdemeanor, aggravated misdemeanor, or a felony, then that juvenile record will be forever open to the public. And this includes dismissals too, so where the person was not found guilty of the offense. And then if it is if the juvenile did commit what would be a aggravated misdemeanor or a felony, then what the court does is they do a balancing test. They look to see whether it's in the best interest of that juvenile to have their record sealed, or if it's in the best interest of the public to have access to that record. Okay. So you will see that this, as I went over juvenile sealing, you will notice that it's a lot more complicated than the adult record clearance. And I think that's just because the legislature first passed the juvenile sealing and then they passed these other ones, but didn't go back and make the juvenile sealing more equitable. But you will notice that Iowa is essentially treating youth worse than adults when it comes to record clearance. Our misdemeanor conviction expungement statute, this is our newest expungement statute. What it covers is eligible misdemeanor offenses. There are a lot of caveats to this. A person needs to wait 8 years from the date of the conviction before they can apply for expungement. While they're applying for expungement, they can't have any current pending criminal charges. They can't have had more than one deferred judgment, which I'll go over what that means. And all the court debt needs to be paid in the case they are wanting to expunge. It's also once in a lifetime. So they can only lay this card down once. And a lot of what we do at the clinics is the attorneys advise clients on where, if they have more than one option, like where they should lay that card down. The only instance where they could get more than one application for expungement is if they were charged with multiple offenses that arose from the same incident. So if they were charged with theft, but then also like during a search, they found like drug paraphernalia that they, and if the state decided to open two separate cases, then they could basically combine those for this expungement and get both of those cases expunged. The effect of it is pretty good. It's not available to anyone once it is expunged, except by court order. But the statute doesn't really say what a person needs to do to get a court order. But I haven't really seen an issue with that so far. There are a lot of exceptions to this kind of expungement. OWIs are not eligible, sex offenses, domestic abuse, assault, involuntary manslaughter, harassment, stalking. Obstructing justice is things that are charged as interference with official acts, things like that. Any weapons charges, and then any elder abuse or child endangerment, child abuse charges, those are not eligible for this kind of expungement. So what we do at the clinics is we basically, if a person has more than one option, we are helping them decide where they should lay that card down. So with Iowa, if a person goes to Iowa Courts Online, anyone can do that and look up a person's records. And then what you'll see on there is not only what they were charged, not only what they were convicted with, but also what the initial charge was. So sometimes a person might be charged with a felony, but they can plead it down to an eligible misdemeanor. But on Iowa Courts Online, it will still look like a felony. And so a person, like a landlord or a potential employer who might be looking on Iowa Courts Online might see, oh, this has a felony case number. It says that they were charged with a felony, and they might not understand that they actually are not a felon and that they actually were able to get it pled down to a misdemeanor. But because it looks worse than it is, those are sometimes good ones to choose to expunge. And then sometimes, employment or housing is more of a barrier for a client. And if that's the case, then usually crimes of dishonesty, theft crimes, things like that are better choices to pick for employment issues. But if housing is an issue, then drugs or violent crimes are usually a better option to pick between. And then sometimes a person might be able to eliminate a whole category of crime. If they have 2 thefts and 1 assault, we usually will advise a person, it's probably will be better for you to expunge the assault to get rid of that whole category. But then sometimes, the ones that we suggest, clients, they actually aren't causing them barriers. And so usually just asking them is a good way to figure out what's causing them the most barriers as well. Looks like we have a couple questions. Having trouble scrolling up. What if
The first
were
question
told-
is, what if they were forwarded to adult court prior to 2015? Does this statute have a mechanism of retroactivity or just going forward?
That's a good question. Unfortunately, no. The juvenile sealing statutes are not retroactive. And retroactive means that a person who has it before 2015 can actually have the newer law applied to them. So yeah, unfortunately, that's not the case for some of it. I will say for juvenile sealing, yes, the person before 2015 can ask the court to retroactively seal their juvenile case if they qualify. But if it's the one thing I didn't go over is confidentiality orders with juvenile cases. If a person doesn't qualify for juvenile sealing because they might have gotten, subsequent convictions, or they're not yet 18, for cases before 2015, they're not eligible to get that case confidential. That mechanism is not retroactive. But for cases going forward, if they don't qualify for sealing, there may be other record clearance, like a confidentiality order, which would apply to them. But confidentiality orders are not as good as sealing because they still can be seen by a lot of people without a court order, like the U.S. Armed Forces, schools, Department of Corrections, judges, lawyers, superintendents, things like that. So while it's something, it's still not as good as a sealing order. Next question, how can I get more updates on the upcoming clinic for Sioux City? You can just email me. I will have my email at the bottom or on the last slide of this presentation, but yeah, we haven't planned that one yet, but we are planning for that one for later this year. So yeah, you can just email me. Next, I'll go over our dismissal acquittal statute. This covers dismissals, acquittals, and then sometimes if you're looking at Iowa Courts Online, you'll see things like transferred, withdrawn, not filed, or it's just not clear like what happened to the case, but it was just abandoned for whatever reason. And so a person is able to get these cases expunged. If it is expunged, it doesn't mean that it's destroyed. What it means is that the public can't see it, but it still can be seen by court plus anyone on the deferred judgment docket, which is law enforcement, prosecutors, judges, and judicial branch staff. But otherwise, the public should not be able to have access to it. And some people might think, it was dismissed, the person wasn't convicted, why do we need this kind of expungement? But really, it's to combat stigma, discrimination, and racism. As I went over those stats earlier in the presentation, with minorities being stopped more by police, potentially having more cases. And so getting rid of those dismissed cases is beneficial. And in America, we're supposed to be innocent until proven guilty, but in reality, that's not always the case. A person doing a rudimentary search on Iowa Courts Online could see that they were charged with things and not understand that it was dismissed. And some things that they might be charged with could be pretty serious, and judgments can be made based off of that. There are some limitations to this. A person is required to pay all the court debt in the case, in the dismissed case that they're seeking to expunge. Yes, Iowa does charge clients in dismissed cases and acquitted cases of court debt. Not all states do that. A person must wait 180 days from the date of the dismissal before they can get it expunged. This can be waived for good cause. I have had that waived in some instances. If it's an acquittal, it can't be the result of insanity. If it's a dismissal, it can't be the result of incompetence to stand trial. And then if for it to qualify, the whole case needs to be dismissed. So if there's multiple counts, let's say that count 1 is a theft, count 2 is an assault. If the theft is dismissed, but the assault is a conviction, then they're not able to just get that theft dismissed count expunged. The whole case needs to be dismissed for it to qualify. If it's a dismissal, can't be related to the grant of deferred judgment. And I'll go over what a deferred judgment is, but essentially the deferred judgment statute has its own way of dealing with dismissed counts. So, and then if it's a traffic case, it has to be an indictable, so a serious misdemeanor or higher for it to qualify for this kind of expungement. So yes, so expungement is only for criminal cases, not for traffic cases unless it's an indictable offense. So now I'll go over deferred judgments. So deferred judgment is a determination, adjudication in a criminal case where a person will plead guilty, but then right before the judge will find them guilty, they basically will give them the opportunity to complete probation, maybe pay off a fine, maybe do get like an evaluation of some sort of complete treatment. And then if they do all the things successfully, the court will expunge the case. So they might plead guilty, but they're not found guilty is essentially what it means. Depending on how the judge gives the deferred judgment, they can give it on a whole case if there's multiple counts, or they can decide, no, I'm only going to give this to you on one count, and I'm going to enter the conviction on the other count. So depending on how the judge grants the deferred judgment, that will determine whether the whole case gets expunged or if like only like a certain count will. And then sometimes a judge will say, yeah, we'll give you a deferred on this case, but also we're going to dismiss related counts. And so if there are like a mixed bag of deferred, something that was a deferred, but then like a count was dismissed, if they successfully complete probation, this expungement will also take care of the dismissed cases too. It's supposed to be automatically expunged, but sometimes clients in rural areas might not have probation offices, or they might have a shortage of probation officers. So they're usually placed on unsupervised probation. And so if they do everything that they need to do, they just need to let the court know that they've done everything, and then the court will expunge it at that time. So, but usually these are automatically expunged once the person successfully completes probation and pays off the debt. The reason why I don't like deferred judgments is because confidentiality of a deferred can be waived on Department of Public Safety and Division of Criminal Investigation background checks. Usually employers and landlords have a box on their applications that say that have like waivers for a person to waive their confidentiality of their deferred judgments by allowing them to get the DCI report that will show their deferred judgments, but these waivers are not written very clearly, and people don't know that they are waiving their rights to have their deferred judgments exposed. So a lot of times we'll have people call Iowa Legal Aid or come to the clinics and say, hey, I got this case expunged. My defense attorney told me that, it was going to be expunged. I didn't have to worry about it. And then what we find out after talking with them more and getting more information is that they actually got a deferred judgment, and they are checking this box on job applications and housing applications and waiving their confidentiality of their deferred. The next I will go over all together. So public intox, possession of alcohol under legal age, and juvenile prostitution. Yes, Iowa does charge juveniles with prostitution rather than seeing them as a human trafficking victim. I'm not sure why. I haven't seen too many of those, maybe like 2 or 3 since I started doing this work, so I don't see it too often, which is good. But essentially, if a person gets a conviction of one of these offenses, and 2 years following that conviction, if they don't get any other convictions, like other than like traffic or simple misdemeanor traffic offenses, then they can get the PALA, the public intox, and juvenile prostitution conviction expunged. There's no requirement that fines and fees be paid. It's a loophole with this one. And the legislature gave this one the strongest level of record clearance. It's essentially destroyed. It's not available to anyone. It looks like we have a question. Sometimes even when a PO files a discharge as a deferred judgment, it gets overlooked and records do not get expunged. That can be realized years down the road when which can harm clients too. I also tell clients to call the clerk a few weeks later to make sure that's expunged. Yes, that is true, Emma. When we do see these cases that it was a deferred and they done everything that they need to do, usually it's because the clerk didn't enter in the expungement, or they were on unsupervised probation and just needed to let the court know that they've done everything. But yes, we do help clients get those expunged too. Here's a nifty chart that just goes over everything that I just went over. It goes over the different types of expungement, the coverage, the time, if there's a time limit that they need to wait for, if there's a debt bar, meaning they need to pay off the debt first before it's eligible for expungement, and if there's a limit on the number. So a person can have as many dismissal expungements as they qualify for. They can only get 1 misdemeanor conviction expungement in their entire life. A person's only entitled to 2 deferred judgments in their life. Juvenile sealing, no limit on the number, but just can't have subsequent convictions over a simple misdemeanor. You can have as many juvenile confidentiality orders if you qualify, if it's after 2015. And there's no limit on the PALA, public intox, and juvenile prostitution, as long as they don't have a subsequent conviction other than simple misdemeanor traffic cases. And then this is expungement relief from weakest to strongest. On the strongest, we have the PALA, public intox, and juvenile prostitution, because it's essentially destroyed. No one has access to it, not even by court order. On the weakest side, we have the deferred judgment, because you can waive the confidentiality of it. So now I'm going to go over barriers that remain after expungement. So expungement record clearance only covers the court record. It doesn't cover agencies' records, police departments' records. So there's no mechanism for getting those agencies. There's no directive from the courts to except for Department of Public Safety in some instances, but there's really no directive for these other agencies to expunge their local files. And so sometimes we have issues with some cities' local police departments who provide background checks for landlords. I think Dubuque and Davenport does this. And so there isn't a way to expunge or to stop the local police department from providing information on expunged court records if they have their local police department records. There also are issues with housing and employment discrimination for records that can't be expunged. In some instances, it's case by case specific, but a landlord or employer's conduct may violate the Fair Housing Act. for discriminating against a person because of their criminal record, and Title VII, which is the Employment Discrimination Act. Depending on the facts of the case, there are some other avenues for getting justice in that way. And as I went over, the DCI waivers are written poorly, and people are waiving their confidentiality without knowing. And then there are thousands of private background check companies out there that essentially buy they buy data from the judicial branches. And once they buy that data, the next day it's stale because the courts are updating their records, things are getting expunged, and the private background check companies are not updating their records as fast as the courts are. And so if it happens that a private background check company reports expunged information, a person does have Fair Credit Reporting Act rights that we can help enforce if that is the case. So now I'm going to go over court debt. We also help with this. So court debt can be owed in a criminal case, a juvenile case, and civil cases. It's even charged when criminal cases are dismissed. And many kinds of court debt can be owed: punitive fines, victim restitution, repayment of defense costs, and jail fees. And the type of debt affects essentially what their options are. Iowa is one of the states that does charge indigent clients dollar for dollar for their public defender. Other states don't do this, and it's questionable if it's constitutional. But that's a fight for another day. But essentially, what we do at the clinics is we look at what can be eliminated. We have a web scraper that can pull all the person's court debt from Iowa courts online, and so we're able to analyze what we can do for that person. So we look at whether any debt is past the statute of limitations. We look at whether or not they qualify for a 910-7 hearing, which essentially is a hearing where they can request a modification of their court debt to get it lowered. It's discretionary hearing and only for those who are under supervision. Whether their debt can be eliminated in a bankruptcy, it's a pretty big decision, but sometimes it does make sense for some clients to get a bankruptcy to help with their court debt. And then maybe there might be a jurisdictional challenge to the court debt. And then Polk County is one of the unique counties, I think the only county in the state that has a room and board appeal where they will reduce Polk County jail fees to 1 month stay, which is pretty nice. We've been able to get rid of even like 5 figures of jail fees for clients in Polk County, which has been pretty life-changing for clients. And then for what can't be eliminated, we are advising the clients on what is the consequences of the different debt in different cases, what debt they should pay off first. Maybe, getting a case expunged is more of a issue for them. So if they have court debt in that case, they should focus on that first. Maybe it's a license issue where court debt is holding up their license or car registration. So focusing on that debt would be a better choice. Looks like we have a question. Would there be any interest for clean slate initiatives, basically revamping our expungement statutes to include retroactivity to juvenile misdemeanor offenses before 2015, or other low-level crimes? Benefits outweigh the costs with Iowa workforce shortage. Research shows people age out of crime by 25. Iowa legal aid cannot lobby, I will say, so I can't push for that, but I think there are other agencies out there that would be interested in that. I definitely think if we did revamp it, it would help a lot more people, and there's good economic benefits to that of providing more jobs for folks and helping people contribute to the community. Next, I will go over one of my biggest frustrations when it comes to court debt, and what I see for our clients. So Iowa Legal Aid, we help clients who are indigent, and we usually see a two-step process to a driver's license suspension for non-vehicular crimes. So any non-conviction court debt, so civil cases, juvenile cases, and dismissed court debt, that can't put a hold. If the person owes that, they can't put a hold on their registration or their driver's license. The only thing that can do is prevent them from an expungement. But if a person has conviction court debt, that can put a hold on their car registration, so they can't renew the car registration or they can't register a car. And if they have vehicular related conviction court debt, that can put a hold on their car registration and their driver's license. So what we usually see for our clients, a lot of our clients are on SSI or SSDI, and they might get a conviction for like a petty theft. And let's say, like, with the attorney's fees, fines, surcharges, they owe about $1,000 to the state. But because they are on SSDI, they can't afford to pay that off, and they default on their court debt. And now the clerks send a notice to the DOT to suspend their car registration. But of course, they're not going to stop driving. They have, they might need to get to medical appointments, might need to drop kids off to school, things like that. And so they're continuing to drive because they need to make ends meet. And now they get pulled over, and now a new conviction for driving on expired tags, which is now vehicular related. A vehicular related conviction, and there's more court debt that's tied to that, but because their financial circumstances haven't changed, they now default on this new expired tags charge. But of course, they're not going to stop driving because they have places that they need to go, things that they need to do, responsibilities, and now their license is suspended. And now they're driving on a suspended license, and that eventually turns into a criminal case, driving while barred, which a person can serve jail time. And it's a horrible cycle that we see our clients fall into time and time again. There's not a lot that can be done. There's a lot of barriers to this. The law requires that a financial statement be so essentially the way to get a person's license or car registration back is to they need to get on a payment plan with the county attorney or Iowa Department of Revenue, whoever collects for that county. And the law requires that a financial statement be used to determine the amount, but there's really no guidance on what should be considered in the financial statement. And there's no uniformity across the state. Like we serve all 99 counties, and so we've tried to negotiate payment plans on behalf of our clients. And there's really no uniformity. Some counties require massive down payments. Some don't allow person to pay in cash. A lot of our clients don't have bank accounts, so that can be a barrier. And then the law only allows 5 payment plans in a person's entire life. And so if a person defaults on their plan, they have 15 days to provide a new financial affidavit to get a new payment amount. But sometimes, working with the county attorneys or the IDR, it's hard to get them to sway on that. Many counties increase the down payment based off of the number of defaults, which really is a misunderstanding of poverty for our clients. If they're struggling to make ends meet, increasing the down payment is not going to help them. In many counties, many people owe court debt in more than one county, and they need to set up individual payment plans with each county. And coordinating that can be a huge headache for our clients, and getting the county attorneys to agree to an affordable payment plan for the clients that they're not paying like $500 for 5 different plans. And it's really a catch-22 because our clients, they want to be able to get to work. A lot of times they will find jobs, but then they can't drive, and then because they can't drive, they can't get to the work to get the money to pay off the fines. our clients want to pay off the fines. They don't want to have these issues. They want to be able to work. They want to be able to contribute to society and to move on with their life. And just these barriers that the state puts in front of them is a huge issue. And something that we are looking at ways of changing. It's like we have a couple of messages. Let me. Oh, those aren't for me. Okay. So here are some of the faces of clients that we have helped. We've helped one client who was a nursing home resident whose brain injury left him in a vegetative state, nevertheless was threatened with incarceration through his guardian for failing to turn over his entire Social Security allotment to pay off decades old court debt. We were able to help him in that situation. EJ, a disabled woman who was threatened with jail and driver's license suspension due to owing indigent defense fees owed to the state for a dismissed case. JE, a victim of domestic abuse who was forced to repay the state for attorney's fees to defend a meritless contempt brought by her abuser in her own protective order without due process of law. CF, a parent in a non-criminal juvenile action who went into foreclosure because she couldn't afford both her mortgage and her payments towards court appointed attorney's fees, which both were assessed and collected without regard to her ability to pay. And DB, a single mother just re-entering society after a period of incarceration who was still homeless despite working 40 hours per week due to illegal garnishments that reduced her paycheck to as little as 19% of gross wages. A lot of our clients that we work with are a lot of our clients that we work with are women. The majority are, and some of our big impact cases are women who have been victims of domestic violence, who entered into the criminal justice system as a result of that. So I'm going to go over a couple of some of our. I won't go into depth on our appellate cases, but just an example of one. We had a defendant who was charged with 2 counts of contempt for failure to appear as a material witness in a murder trial because it was her abuser and she was afraid to testify against him. It was her failure to appear as a material witness case was charged as a felony, and it ended up being dismissed. And so it looks like felonies on Iowa Courts Online. We were going to appeal, but then we reached a settlement with the Attorney General's office to increase the security level of the case to basically make it confidential. This next case was a big case that actually ended up going to the U.S. Supreme Court, but they decided not to hear the case. But and we ended up losing this one. But we made the argument that our client in this case was being treated differently because of her poverty as a violation of equal protection, in that she shouldn't have to pay her court-appointed attorney's fees to get the dismissal expungement. But we ended up losing this one. But in this case, the defendant was a victim of domestic violence. She was actually stabbed in the eye by her abuser and was blinded, and was continually abused by her client. In the process of getting abused, neighbors called the police. She didn't want to let the police in because she knew that if she let them in, it would, through previous experiences, it would make the matter worse for her. And so she prevented the officer from coming into her apartment, and then the officer charged her with assault on a police officer and with domestic abuse assault, even though she clearly had bruises on her. And so a lot of the clients that we help have similar stories like this, where they themselves are victims. This is a similar case. So I'm going to actually fast forward, since we're running closer out of time, to see if anyone has any questions. We did have a couple of juvenile, where we tried to change some of the juvenile law where for juvenile dismissed cases that are public, we tried to use the adult expungement dismissal statute to try to get some of the juvenile cases expunged, but we lost those ones. But we do have a couple of other pending cases right now for parole violations that have the felony case number that look worse than they are. Hopefully we'll be successful with that, but that's pending right now. And we have a Polk County appeal going on right now where some judges are splitting up expungements. So if a person has a conviction and a dismiss count in one case, they were only expunging the conviction count and leaving the dismiss count public record, but then they also did not properly redact the physical file, so you could still see information of the conviction count. And so we did file that in March, and so that is a pending appeal. If you have any questions or if you want to connect, we work with a lot of community partners. So if you are interested in hosting a clinic in your area, you can email me and then we can see if that's something that we can provide. We typically do about 12 to 15 clinics per year, and we usually plan those out at the end of the year, so for the next year. And so we work with a lot of Iowa workforce development offices throughout the state to host clinics. Usually we need like a clinic's location where we're able to have like some meeting spaces or like a big room that's big enough to meet with folks. And then we usually provide the volunteer attorneys and the client files and everything. So we work with a lot of community members. They help us get clients and referrals. And if that's something that interests you, here's my contact info. You can email me at eddy@iowalaw.org. And if you have any questions, let me know.
Thank you so much, Ari, for that information. I know that was a lot of information on several topics that I think that we as folks working in the reentry space have lots of questions about. So I think there was a lot of clarifications in there and some, like I said, some great info. So as Luke commented earlier in the chat, we will, or maybe it was Hannah, we will send out copies of the slides as well as contact information for Ari as well. So it looks like we're done just a couple minutes ahead of schedule. So we'll go ahead and take a break, and then we will come back at 11 o'clock for our keynote speaker of the